Today's video is brought to us by GunSpot. GunSpot is an online marketplace where you can bid on all kinds of 2A tools, accessories, and more. There are dealers and individuals from all over the country, and not only do you get great pricing, but you never have to pay out-of-state sales tax. Sellers don't have to worry because the costs are clearly defined, and their website also has a cool battle station where you can keep all of your auctions and bidding all in one convenient spot. Thanks to GunSpot for being a friend of the channel, and to learn more, check out gunspot.you-know-what. Hey everybody, welcome back to the channel. I appreciate your time. Thank you for watching. Monday, 2 days ago, a filing in a very long anticipated case was made by the Attorney General in Maryland, and this is a case called Maryland Shall Issue versus Hogan. And at challenge here is Maryland's handgun license / qualification requirement. And this case was initially filed way back in 2016, and for the last, I forget how many months, it's been on hold pending the New York State Rifle and Pistol Association versus Bruin decision in the United States Supreme Court, because a lot of this would have been depending on is the Second Amendment applicable to carrying guns outside the home, which we all know it is. The United States Supreme Court, specifically Clarence Thomas, in his so eloquently written decision, put the smackdown on the anti-gunners quite a bit. For instance, this country is now shall issue. Well, New York's trying to fix that, but this case has been waiting for that decision. And this week, Monday, the Attorney General in Maryland filed his brief on why this case should be tossed out. And remember, in the Bruin decision, Clarence Thomas said that the only test that remains to decide whether a perceived infringement, a law that's against the Second Amendment, can stay on the books or not, is the text, history, and tradition. The text of the Second Amendment, there's nothing in there other than shall not be infringed. And then the history and the tradition of the country around the time the Second Amendment was adopted, which was 1791. Wait till you hear what this Attorney General says related to the history and tradition that he's going to try to bamboozle this judge with. Here on the screen is the first page of the filing, and you can see it is Maryland Shall Issue, like I said, versus Lawrence Hogan. We'll go through a couple things together. The introduction. The plaintiffs challenge specific aspects of Maryland's handgun qualification license law, which requires handgun permit applicants to pass a background check and take a firearms safety training course, thereby ensuring that those who acquire handguns are law-abiding, responsible citizens. The district court correctly found that Maryland's law furthers that permissible goal through objective, clearly defined criteria and minimal administrative requirements that do not prevent ordinary, law-abiding, responsible citizens from obtaining handgun licenses. Accordingly, the district court should be affirmed. So they're telling this appellate court, hey, listen, they got it right in the lower court, and you should just toss this out. Let's go over the issue presented for review. Is Maryland's handgun qualification license law consistent with the historical tradition of the Second Amendment, where the law, 1, is designed to ensure that only law-abiding, responsible individuals may obtain a handgun, and 2, does so through non-discretionary criteria and with minimal administrative burdens. Right now, I'm going to tell you about Maryland's license and what's required, and then we're going to go back into the lawsuit here, or at least into the filing, this brief, and we'll talk about the history and tradition part that the Maryland Attorney General is going to try to hang his hat on. So the Maryland HQL, it's called Handgun Qualification License. You have to be at least 21. You have to be a Maryland resident. You have to have completed a firearms safety course within 3 years of your application to get this license, and you cannot be federally or state prohibited. Now, the course is a 4-hour minimum. There is a fee to it. I think it's capped at $50 by law. It has to go over things like Maryland firearms law, firearm safety in the home, handgun mechanisms and operation, and you must fire at least 1 round of live ammunition. Again, this has to be done before you can apply for this license, this safety course. Now on the screen, back to the brief, we'll go with B here. The firearm safety course requirement of the handgun qualification license law is consistent with the Second Amendment's historical tradition of a responsible citizenry trained in the use of firearms. And this is where the BS starts to fly. Maryland's requirements that HQL applicants complete a firearms safety course ensures that handgun possession is limited to law-abiding, responsible citizens by making sure that individuals who may use a handgun have some knowledge and training to do so safely. This fundamental exercise of Maryland's police power is supported by the historical traditions of the Second Amendment. Oh, really? Please do tell. At the time of the founding, most men had to participate in their state's militia. And consistent with the English tradition, mandatory training obligations came with this militia service. Indeed, prior to the ratification of the Constitution and the Second Amendment, many states had enacted laws that required training in the use of firearms. Now, if you've been paying attention, you picked it up right away. This Maryland AG is trying to pin his hat on, hey, if they're in the militia, they're supposed to have been trained. However, several Supreme Court decisions have split that. Just the Second Amendment does not apply to the militia. And we, the people, do not have to train like the militia. We have a right to defend ourselves. So he's just not even looking at that part where we're able to keep a gun in our home for self-defense, and you're guaranteed your right when you go outside your home for self-defense. And remember, you can't make the whole island of Manhattan a sensitive place. But he's hanging his hat to the militia training that was around during the ratification of the Second Amendment. Let's check the rest out. The year after the Second Amendment was ratified, the Second Congress enacted the Uniform Militia Act of 1792. This law required that able-bodied male citizens between the ages of 18 and 45 be enrolled in the militia, and imposed the duty of the commanding officer at every muster to cause the militia to be exercised and trained agreeably to the rules of discipline. To implement the Militia Act, several more states enacted laws requiring training. These laws did not just reflect common sense and practical commitment to state security, they were contemplated by the Second Amendment's text. In Heller, they noted that the adjective well-regulated implies nothing more than the imposition of proper discipline and training, and that when the able-bodied men of the nation were trained in arms and organized, they are better able to resist tyranny. Noting that a well-regulated militia cannot exist unless the people are trained to bearing arms. And these laws would have also had the complementary effort of ensuring that the men of the community, starting with their youth, would be provided with the training necessary to handle and use firearms safely in any context. Actually, no, that was for preparing for war, for invasions, probably from England, the French, or the Native Americans. All this was going on at the time. This was the standing army. This had nothing to do with people walking around the cornfields looking to protect themselves from any other type of attack. But this is what they're trying to hang their hat on. And I'll tell you that every other state that's trying to restrict the Second Amendment is going to be paying attention to this closely. In the first decades of the 19th century, as the country grew more democratic and rambunctiously individualistic, the duty-bound concept of militia service withered. By the 1850s, the perceived threat that had prompted the inclusion of the Second Amendment in the Bill of Rights, the fear that the national government would disarm the universal militia, had largely faded as popular concern, but the right to keep and bear arms was highly valued for purposes of self-defense. That the vibrancy of the right depends on a responsible citizenry is woven throughout the Second Amendment's historical tradition. See Heller. No doubt, a citizen who keeps a gun or pistol under judicious precautions practices in safe places the use of it, and in due time teaches his sons to do the same, exercises his individual right under the Second Amendment. For example, in his opinion dissenting from a finding of mootness in New York State Rifle and Pistol Association versus the City of New York, Justice Alito recognized that a necessary concomitant of the core Second Amendment right to keep a handgun in the home for self-defense is to take a gun to a range in order to gain and maintain the skill necessary to use it responsibly. However, that case was where New York wouldn't let anybody bring a gun anywhere, including a range. That had nothing to do with what they're trying to make it sound like, where, you guys should be all going to train required according to the government. And this is where he's starting to step in it a little bit. All right, one last paragraph, I promise. This backdrop makes clear that regulations designed to ensure that those who exercise the right know how to do so responsibly, such as a firearm safety course requirement of Maryland's HQL law, fall well within the type of reasonable firearms regulations that are interwoven within the Second Amendment's affirmative self-defense right. See McDonald. We made it clear in Heller that our holding did not cast doubt on such long-standing regulatory measures as prohibitions on the possession of firearms by felons and the mentally ill, laws forbidding the carrying of firearms in sensitive places, such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. We repeat those assurances here. Despite municipal respondents' doomsday proclamations, incorporation does not imperil every law regulating firearms. So it's a bold step by the Maryland Attorney General to say, you know what, Second Amendment says everybody should be well-regulated, right? It should be well-trained, and that's what we're trying to do for our citizens here in Maryland. However, there's several parts of the Second Amendment. Well-regulated militia being necessary. I can't even talk. A well-regulated militia being necessary to the security of a free state, comma, means different clause. And then the right of the people to keep and bear arms shall not be infringed is totally different and has nothing to do with militia service. Yet this clown is trying to pull the wool over the Fourth Circuit's eyes, and now we will see what happens going forward. So this is just a day and a half old, and as this case continues to unfold, we definitely need to pay attention to this, because every state that has a licensing requirement is watching this, because if this falls, they all fall. And of course, if Maryland loses, it'll keep going up the ladder until it makes the Supreme Court. But this bears watching nonetheless. If you want information on the Second Amendment, whether it's good, bad, ugly, or indifferent, to include videos in where I just put out the facts, whether people want to hear them or not, happens sometimes, subscribe to Guns and Gadgets right down below. Hit that button. Also, like the video, share the video, hit that bell icon to all notifications. It takes you about 8 seconds to do all this stuff, but it definitely helps the channel, and by commenting, it also gets it through the algorithm as well. So if you want to see this channel continue to make waves in the anti-gun areas that it's really pissing off, then if you could do that, it would help me greatly. Guys and gals, thank you so much for your time. I appreciate each and every single one of you more than you know. And until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. That's what it's for. And for some reason, politicians are really scared about that. Oh well, take care.